Hi everybody, Dave Sugden. Today we are going to talk about the issue of relevance, and specifically the issue of relevance as it comes up during trial. Because there's the practice of law or the study of law in general, and then there's the practice of law during trial. And in trial we have to be both fast and precise as these rules and issues come up, and so that's what we're going to work on today. And so first, what I want to introduce is a methodology for us to consider any evidence question as it comes up during trial. And the reason we have this arrow is because we want to think of any evidence question in this order. And the reason why we want to have this discipline is because during the heat of trial, we may hear things that can suggest obvious objections, but we may miss less obvious but more important objections. And so, for example, if we have a situation where we hear some witness on the stand saying, "Mr. Jones told me that," and all of a sudden we hear this witness making a reference to a third-party declarant, we can think, oh, hearsay. Let's make a hearsay objection. But hearsay has a lot of exceptions, and so that may not be the best objection to make. There may be better objections as to relevance or foundation. And so as we think of these issues, we always want to start with relevance. We're going to talk about how to make these arguments during trial. Next, we want to look at the issue of foundation. Does the witness have personal knowledge about what he or she is talking about? Or does the document that's trying to be introduced into evidence, has there been a showing that the document is what the proponent claims it to be? Then we get to hearsay. And we'll have there are other classes that we have where we show the best way to not just identify hearsay, but identify objectionable hearsay. And we'll talk about the best way to, in the event there's objectionable hearsay, how do we find an exception quickly that may apply? Finally, we'll look at exclusions and limitations. And this has to do with evidence that's relevant and there's a foundation, there's no hearsay issue, but for some reason the law has decided to either exclude or limit this type of evidence. And so this has to do with evidence that may be protected by a privilege, an attorney-client privilege, or a doctor-patient privilege, or a character evidence area where there's going to be a limitation on the admissibility. Next, we'll look at the issue of prejudice. And this, again, this is evidence that's relevant, but the evidence may be substantially outweighed by some type of prejudice, or it may be substantially outweighed by how long it will take to introduce this evidence, or this evidence may confuse the jury. And so that's when we look at the issue of prejudice. And finally, we will consider the form of the question. So today, let's take a look at the issue of relevance. And as lawyers, the issue of relevance can often seem intuitive. We just know this, and so therefore we can argue it colloquially. And oftentimes you'll see lawyers arguing back and forth or with the judge as to whether or not a piece of evidence is relevant. And what we'll often see are really two errors that lawyers will make. And one has to do with this issue of the ultimate fact. There will be arguments between lawyers or with the judge where the argument turns on whether or not this disputed piece of evidence proves the ultimate fact for which it's offered. And if that argument is made, and then the other lawyer will go back and forth saying, no, it does prove the ultimate fact. And the reality is that if you're arguing whether or not this piece of evidence proves the ultimate fact for which it's offered, you're actually missing the issue of relevance. You're arguing too much. The other issue we see come up is this idea of, that's not very good, let's try that again, prejudice. And you'll hear lawyers say, Your Honor, this piece of evidence isn't relevant because it's so prejudicial. And as we saw in the slide before, if you're arguing prejudice, we've already dealt with relevance. What you're essentially saying is you're essentially conceding this piece of evidence is relevant, but it's too prejudicial. And so when we think about relevance, we really want to be disciplined and argue the issue in a way that's consistent with the rules of evidence, the evidence codes. So here, the first piece of our working rule is that irrelevant evidence is never admissible. And here, the source for this rule is Federal Rule of Evidence 402. In California, it's California Evidence Code Section 350. And in essence, they say the same thing, which is irrelevant evidence is never admissible. And the reason we start there is because once a judge determines that evidence is relevant, there's a great deal of discretion that's permitted to determine whether or not that evidence should be admitted. On the other hand, judges do not have any discretion to allow evidence that is irrelevant to be admitted. So we'll always start our analysis there. The next working rule is that all relevant evidence is admissible unless an exception applies. And here, again, we look at Federal Rule of Evidence 402, and in California, we're looking at Section 351. And then, in terms of the exceptions, there are many that apply. And when we think about the exceptions, that is, in essence, the rest of the issues we saw on that first arrow. In other words, are there hearsay issues? Are there foundation issues? Are there issues for excluding it because of a privilege or some other policy reason? And so that's the working rule as it applies to evidence. Then how do we apply it? And here we look at how we're going to first approach these issues. And again, the first question we're going to ask ourselves is the evidence relevant? Because as we saw in our working rule, if the answer is no, the analysis ends. The evidence is not admissible. If the answer is yes, we then keep going. And so how do we answer this question? Again, we look to the rules of evidence and we have a working rule with respect to what is the definition of evidence. And again, in California, we look at the definition which is found in Evidence Code Section 210. And in the Federal Rules of Evidence, there's a test, which is found in Evidence Code Section 401. And they say close to the same thing. What Evidence Code Section 210 says is evidence is relevant if it has a tendency in reason to prove or not prove a disputed fact that is of consequence to the action. What Evidence Code Section 210 also says is that the credibility of a witness or hearsay declarant is always relevant. And so when we think about how to approach these issues, we want to have this definition in mind. Under Rule 401, it's very close to Section 210, and it says that evidence is relevant if it has a tendency to make a fact more or less likely than it would be without the evidence. The second piece of that test is the fact has to be of consequence to the action. Under Federal Rule 401, it's not required that the fact actually be disputed. So that can sometimes be a distinction, but still it has to be of consequence to the action. And so in the event that there is an objection made over relevance, what we want to do as the proponents of the evidence is do an offer of proof. And again, in terms of how to make an offer of proof, we go to the rules of evidence. And so in California, we look at Section 354, and that essentially outlines what you are to do if you are the proponent of a piece of evidence where there's been an objection and you want it in. In fact, you have to do this in order to preserve the record for appellate purposes. In the federal rules, there's actually no rule that identifies what to do for offers of proof. However, if you look at the advisory committee notes under Rule 103, it actually cites Section 354 as an appropriate way to make an offer of proof. So how do we do that? And what Section 354 says is you, as the proponent of the evidence, have to identify the substance of the evidence, the purpose, and its relevance. And so in essence, you tell the judge, you say, Your Honor, the substance of the testimony is that Mr. Jones will testify as to the following. Then you will describe the purpose of that evidence and say the purpose of that testimony is to show. And then you go to the rule of evidence and the definition and say, in the event that evidence shows X, Y, and Z, that's relevant because it has a tendency to show and then tie it to a disputed fact that's of consequence to the action. So that is how you tackle issues of relevance. I would encourage you to jump online at Evidence at Trial to see other online classes that we have, as well as look for live events where you can do a deep dive and learn how to master these rules of evidence. Thanks for joining our community.